jurisdiction as the topic of our discussion also changed quite a lot. I would say drastic changes. There were days where we could walk into a bank or we call an agent, you get a company registered. Today it's a process going through 10, 15 days of KYC process, and even banking, financial institutions, compliance process. I mean, world has changed. So that's my point. It's the last 3 decades of my experience here. Anyway, I don't need to explain much about all this. I'm sure all the people participating here are aware of all these issues now going through in our world. Now, the topic out here is offshore jurisdiction. Basically, offshore, as we know, the word itself is quite self-explanatory. It's a company registered outside your jurisdiction, basically, in order to obtain the best of corporate commercial transactions. And many people use offshore entities for different purposes. We will get into that. I think my distinguished co-speaker here, Peter, will explain about various uses of offshore entities. But in general, offshore entities are we call it 3 or 4 different categories. Offshore corporations, basically, it's more of a substance company registered with presence in the jurisdiction where it's incorporated. And then we have the commonly used international business companies, as we call IBCs. These are companies where you don't need much substance. You can use it wherever you are and in any business, any legal business, as possible in world. Now, again, there are a lot of changes to taxations and other aspects to IBC use, but we'll get into that at a later point. And another common form of offshore jurisdiction is trust and foundations. Basically, these are for special purposes, family succession plan, and various other purposes. People set up trusts and foundations, and an offshore jurisdiction is quite neutral in that sense for setting up such a structure. Then we have the limited partnership structure, which is commonly used for financial investment, fund management, that sort of common use. These are the common types of offshore companies or entities that we commonly use for various businesses. Go to the next slide, please. And next one. Right. Yeah. Common jurisdictions, most of us know, offshore entities, mainly at British Virgin Islands, as we call BVI. And then Cayman is another popular jurisdiction where many financial institutions, fund management companies, and even listing IPO purposes have been used. Then we have the new kids on the block, Seychelles, Panama, these kind of jurisdictions where commonly people incorporate for various purposes. And these are common, although we say common jurisdiction, there are quite a lot of other jurisdictions come up with offshore regulatory framework, which can be incorporated. We can reach a whole list of entities where our expert teams can guide you through depending on your needs and requirements. But we say these are the common jurisdictions for BVIs or Cayman or Seychelles or Panama. These are the jurisdictions we use or we've seen clients use commonly. Next slide. And now I would cover some of the benefits of using offshore entities. Generally, offshore entities are seen as an entity which we can use for commercial purpose worldwide without any borders or jurisdictional control. and the purpose is generally we see clients using it as a tax optimization, because as we all know, many countries now have huge tax requirements, and offshore entities generally known as at zero or low tax jurisdictions, commonly without any complication of high tax reporting requirements and complications of structuring. That's one of the benefits which we see with offshoring. Another common use we see in generally asset protection purposes, people use an offshore entity instead of using your own name. You can put it under a company or a company with a corporate veil. You can shield the assets and legal claims. That's another purpose or benefit we see generally with offshore entities. Offshore entities are also quite operational flexible. We can use that without much restrictions on a common purpose of commercial transaction in any markets. Generally, that's kind of common understanding. Again, there is quite connected with asset protection, privacy, and confidentiality. This is also another benefit where we use offshore companies. We can put all assets in an offshore entity. You're kind of shield from your personal information being spread around, who's holding the assets. So the confidentiality of these transactions also been widely seen as a benefit of offshore entities. Offshore entities again can be used for, as I said earlier, transaction all around the world without any complication, international transactions with the cross-border activities, and also it can attract skills in various jurisdictions using offshore entities. Again, these are things we can dive into in details with my co-presenters' slides at the later stage. We also see regulatory advantages with offshoring. Many of these offshore jurisdictions are much more simpler in regulatory framework, although it's been changing a bit lately now with a lot of requirements of reporting in offshore jurisdictions as well. But I would say it's still one of the favorable business regulatory framework in offshore jurisdictions generally now. We can also see currency diversification. Offshore jurisdictions can be used with financial institution connection with various currency risk. This is also, again, another benefit of offshoring. These are the kind of common benefits which you see using an offshore entity. We greatly see in offshore entities have been used as a holding vehicle to list in various capital markets. To keep an example, just to say a simple thing like Hong Kong market, half the entities listed in Hong Kong market are supposed to be Cayman Island companies. This is very widely used in Hong Kong capital market. Again, it's because of the flexibility and the regulatory framework of offshoring. And then we see BVI companies also now used as holding company for listing purposes in Hong Kong and various other capital market all around the world. These are the kind of common use which our clients use for offshoring, and also it's a common benefit of offshoring. Without further delay, I can get into the common difficulties clients face these days. We see offshore framework is great. Offshoring is great for various benefits and commercial transactions. But we also see increasingly with regulatory changes that clients are facing a lot of challenges at the moment. Just to name a few things, like financial institutions becoming very tough for getting a bank account for an offshore entity, simply because anonymity and simplicity also goes with the difficulty in identifying things for financial institutions. So therefore, they look at offshoring as a risk factor, which is again one of the common concerns we see from clients. Regulatory compliance aspects, which is again offshoring, many people know as a simple jurisdiction, simple framework, but of late it's been changing and there are a lot of requirements for filing. Administrative burdens, again, this is one of the things clients face at the moment because of regulatory framework change. There are a lot of requirements to file throughout the year. And that's, again, looked at as a burden and concern for many users. And reputational risk, again, is an aspect which people worry quite a bit now. If you tell any commercial transaction, if one part of the commercial transaction is an offshore entity, people say it's a great concern, because of a lot of negative press and publicity around offshoring. People look at it as a reputational risk, but there are quite a bit of work done by many jurisdictions to alleviate these aspects. It's also a tax complication. Nowadays, the world is so much intermingled, and various governments are looking at offshoring and offshore activities quite strictly, and that could be an operational aspect for concern for clients as well. Changes in legislation, again, people don't understand the new regulation, new changes, new filing requirements. This is again a concern for many users. Administrative burden, as I mentioned, transparency and accountability is also an issue. These are the common concerns which you see, but going to an expert team or a service provider with a lot of experience, we can ease all these burdens and concerns, and we are here to help. In any case, our experts are quite experienced enough to help you through these concerns and difficulties. Now, without much delay, I'll pass on to my fellow speaker here, Peter. Peter's ready and raring to go. Peter, over to you.
Thank you, Saji. Good to be here. And good morning and good afternoon to you all as well from myself. Now, I'm going to dive straight into it and kick things off by looking at some of the key regulatory compliance and commercial considerations in offshoring in more detail. And I'll be talking from my experience of advising on BVI and Cayman law for over a decade, but do keep in mind that the choice of offshore jurisdictions is, of course, far greater. So I thought it would be helpful to start by providing some examples of the key uses of offshore vehicles in Asia. This is not intended to be exhaustive by any means, but will hopefully serve as an illustration of the many use cases that are available. So let's start with something that Saji has already briefly mentioned, IPOs. Now, most of you probably know that offshore jurisdictions have historically been very popular for the purposes of listings and raising capital. And as an example, over 80% of all companies listed on the main board of the Hong Kong Stock Exchange are incorporated in offshore jurisdictions such as the Cayman Islands, Bermuda, and to a lesser extent, the BVI. And as Saji has mentioned, most of those offshore companies on the Stock Exchange of Hong Kong are Cayman incorporated. And why is that, you might be thinking? Well, it's almost certainly because offshore jurisdictions do offer a flexible corporate governance regime, particularly regarding things like distributions, they are perceived as neutral, and of course, they are tried and tested in practice. Now, I would add that convenience listings are different to those intended to raise capital for other purposes, such as regulatory reasons, maybe credit rating purposes, or to satisfy insurance requirements. And these types of listings are often conducted on reputable offshore stock exchanges, such as the Cayman Islands Stock Exchange, simply because they offer a lighter touch regulatory approach. As we all know, again, as mentioned by Saji briefly, offshore companies are also commonly used to hold single assets because they are cheap to maintain and offer an additional layer of confidentiality. A lot of Hong Kong real estate and elsewhere in the world continues to be held by BVI companies, for example. And we have other types of high value assets, including shares in other companies, private yachts, private jets that are commonly held through offshore companies simply because their owners may be high profile and want to safeguard their privacy. Now, I'm going to share some interesting statistics with you. In the third quarter of last year, there were over 120,000 active companies in the Cayman Islands, and over 80% of those companies are exempt, which means that they do business outside the Cayman Islands. And by contrast, there were approximately 360,000 BVI companies on the company register in the middle of last year. In other words, 3 times as many BVI companies as Cayman ones. And that's mostly because BVI companies are cheaper to maintain than Cayman companies and are therefore the more popular choice for asset holding purposes. And we do know that BVI companies are incredibly popular in Asia because a report commissioned by the BVI government in the past has in fact identified that over a staggering 40% of all BVI companies have Asia-based beneficial owners. Now, moving on to fundraising and corporate transactions, the BVI and the Caymans do remain among the most popular jurisdictions for structuring investment funds and raising capital, as they are tried and tested in practice. Typically, the Caymans will attract larger, more institutional funds, whereas the BVI is more attractive to smaller funds and emerging managers. And again, to share some insightful statistics, as of June of last year, the BVI had over 2,000 registered investment funds, whilst the Cayman Islands had over 30,000 investment funds in the final quarter of last year. And it's widely estimated that 70% of the world's offshore investment funds are incorporated in the Cayman Islands, and of course, many of them have ties to Asia. Now, offshore structuring is also very popular in the context of corporate deal making. Saji has already touched on some of the high-level reasons for this, but let me build on the analysis by giving you 3 specific examples. First of all, BVI law does specifically permit the directors of a company to act in the best interests of joint venture shareholders rather than the company itself in some circumstances, which of course displaces the common law position that the directors of a company must act in the best interests of the company itself. And so we regularly see, for that reason, BVI companies being used on joint venture transactions in Asia. Secondly, the fact that the rules around distributions, buybacks, and also redemptions are flexible and mostly only require compliance with a simple solvency test in many offshore jurisdictions has contributed to their popularity in corporate transactions, including with respect to special purpose acquisition companies, which have proven to be quite popular in Asia over the last couple of years. And then the final example I want to give is that the straightforward and well-tried and tested statutory merger regime has led to Cayman companies becoming very popular in the context of privatizing Chinese businesses listed on NASDAQ and also the New York Stock Exchange. And the Cayman take-private mechanism has traditionally been used to delist companies from stock exchanges in the US and to relist them in Asia simply to achieve a better per share price, given that many Chinese companies have traditionally been undervalued in the US stock market. Now, in terms of corporate lending, as a firm, we have seen offshore vehicles being used in all types of secured finance transactions in Asia. Many of the deals that we see are incredibly complex, and they do often involve a large number of offshore companies. One of the most important reasons we think that offshore companies continue to be attractive in these types of transactions, whether that's as a borrower or a security provider, is that it's really easy to take security over the shares of these companies and for a lender to enforce against those security interests in the event of a default. And that's because many of the remedies that are available under offshore law are self-help in nature and do not necessitate a secured lender having to go to court. I would also add that the BVI has a well-tested system for registering security interests, which is attractive to lenders. Now, I think in terms of cross-border investments, perhaps the best example of the important role that offshore companies play in Asia is the so-called variable interest structures, or VIEs, which effectively facilitates inbound Chinese investments by overseas investors into restricted sectors. And so what happens in this structure is that overseas investors hold a controlling interest in a so-called wholly foreign-owned entity, a WFOE, for a chain of offshore and potentially mid-shore companies. And to comply with law, what happens is that the WFOE does not have a shareholding in the relevant operational PRC entity. Instead, what it has are certain controlling and benefits transfer contracts, in other words, the VIE contracts, with the PRC target company and its shareholders. In the asset finance space, offshore structures are commonly used to facilitate bankruptcy remoteness, off-balance sheet treatment, and they also permit limited recourse provisions to be used. Now, I'm not going to go into details of this, but effectively, the way it works is that the chain of ownership between the relevant offshore special purpose vehicle is segregated from the rest of the corporate group. If I could have the next slide, please. So moving on to regulatory and compliance considerations in offshoring, I think fundamental question is, how do you actually know which jurisdiction is the most appropriate for a particular project? And what are the types of regulatory and compliance considerations that you should be thinking of? Well, there's probably too many to name, especially for a 60-minute webinar, so I have picked a couple to highlight and the types of issues that have to be considered. So arguably, I think a good place to start is by shortlisting a number of offshore jurisdictions and speaking to practitioners that advise on them. And these types of initial discussions may be helpful for a number of reasons, in my view. First of all, and again, Saji has already alluded to this, there is now a sharp divide between jurisdictions that are more light touch in terms of regulation, including Panama, and those which are imposing ever greater filing and other requirements, such as the BVI, on their controllers. Now, I think the direction of travel is clearly more regulation and more transparency, and this is probably understandable following the Panama Papers, the other papers that followed it, such as the Paradise Papers and the Pandora Papers, the collapse of major financial institutions in recent years, such as Silvergate and SVB, and also the turmoil we have seen in the digital asset space, such as the Chapter 11 bankruptcy of FTX, which has affected a lot of our clients. And so it seems to us that clients are now at a crossroads in choosing an appropriate jurisdiction. Do you go for the least regulated option, or perhaps a jurisdiction that is better regulated at a greater cost, but with a more desirable reputation. I think this is ultimately a commercial choice. And of course, we appreciate that a small family business looking to expand in Asia will have very different commercial considerations to take into account than a large multinational corporation with international investors. Now, when making a decision on a suitable jurisdiction, it might be helpful to consider key changes in law and trends in that jurisdiction, as the direction of travel is often a helpful indicator. So, for instance, we know from recent changes in law in the BVI that took effect earlier this month that the BVI is striving to be a global leader of offshore financial services that complies with the highest standards of transparency and good governance set by the Financial Action Task Force. And we know this because the BVI has made significant changes to its beneficial ownership regime, the timelines within which statutory registers must be updated following a change, and also the additional requirements that must be fulfilled in order to remain in good standing. Take Seychelles as another example. We know from the relatively new virtual asset service providers legislation in the Seychelles that it's trying to make a push in the digital asset space. And so we think that these types of indicators can be helpful to clients in Asia trying to decide on an appropriate jurisdiction to facilitate business expansion offshore. Now, another important issue to consider is whether the proposed business has to be regulated. And even if it strictly doesn't have to be regulated, does it potentially want to be regulated? Regulation, of course, attracts additional cost, but it does bring potentially significant reputational benefits and also better exposure to larger, more institutional customers and investors. And there will, of course, be really important differences between jurisdictions. For instance, the application fees may be lower in one jurisdiction, but does that actually really matter if the application processing times are considerably lengthier than in other jurisdictions? What about capital adequacy and insurance requirements? Do you need local resident directors? What about the AML and KYC requirements? Now, if you do have a business which is conducting any of the potentially regulated activities listed on the slide, then you probably are best served in reaching out to a qualified practitioner. All I will say on this is to highlight that gaming and betting continues to be prohibited in many offshore jurisdictions, whilst it is regulated activity in others. Now, I think any business looking to offshore and consider expanding in Asia must consider the economic substance regulations. Today, there are over 135 jurisdictions that are members of the so-called OECD's BEPS inclusive framework, including the BVI and the Caymans. For those of you who are not aware, BEPS stands for Base Erosion and Profit Shifting. And this is a reference to the fact that entities should not be allowed to artificially shift their profits to low and no tax jurisdictions in which they have no activities. And each member country of the OECD BEPS has implemented its own economic substance legislation. So even though that legislation derives from the same principles and guidelines, there may be important differences between jurisdictions to consider. Now, I'm going to give you some very brief context on what the economic substance regulations are. In short, an entity which is a so-called relevant entity that performs a so-called relevant activity must comply with the economic substance test. And if you do have to comply with the economic substance test, then that means in the vast majority of cases that the entity will have to be directed and managed from the offshore jurisdiction. It will need to have people on the ground. It will need to incur operating expenditure there, etc. And you can see why that might be really unattractive. But there is a saving grace. First of all, if you are an offshore investment fund or you're a tax resident onshore, then you will not qualify as a relevant entity. And second of all, and even more importantly, the list of relevant activities is limited, and I've set them out on the slide. Now, you will be pleased to know that a relevant entity undertaking the relevant activity of holding company business, in other words, just holding shares passively in another company, will only need to satisfy a reduced economic substance test, which does not pose problems in most cases. On the other end of the spectrum, an entity performing intellectual property business might run into significant issues and should obtain legal advice. Now, I'm only going to talk about BEPS 2.0 very briefly because it does not affect the vast majority of businesses, but I think this is a logical place to mention it because BEPS 2.0 effectively constitutes the second phase of the OECD's project, the first being economic substance, to combat base erosion and profit shifting. And among other things, it's designed to ensure fairer taxation and effectively imposes a global minimum tax of 15% applicable to multinational groups with a global turnover of 750 million euros or more. Given that investment funds are broadly carved out, we do not expect that these rules will have a significant impact on Cayman funds, and we also don't think these rules will have a significant impact on offshore financial centers that are tax neutral, such as the BVI and the Caymans. But clearly, this is a space to watch as jurisdictions continue to implement these rules. Now, I think it's difficult to ignore that the impact that blockchain, digital assets, and crypto has on businesses. And in today's age, we know from our own clients that many Asian businesses are seeking to draw upon these technologies and assets to enhance profitability or perhaps to increase market share. But there are some really important legal considerations to take into account. Needless to say, this is a rapidly evolving area. Seychelles didn't have VASP legislation until towards the end of last year. The BVI didn't have such legislation until the middle of 2023. Although not offshore, the US, of course, has been pursuing a very aggressive enforcement by regulation type approach, which has dissuaded many blockchain businesses from operating there, creating opportunities potentially for Asian businesses in Asian economies. But of course, with Trump now in office, we expect this will change, which I think makes the point nicely that blockchain legislation is fast changing and appropriate legal advice must be obtained. Some jurisdictions we know continue to struggle with the notion of crypto as property. Most offshore financial centers, including the BVI and the Caymans, have determined beyond any doubt that cryptocurrency is capable of constituting property, so long as the traditional definition of property is met, which of course is incredibly helpful to Asian businesses because property rights only attach to property. VASP legislation, which governs the provision of virtual asset services, of course, is not uniform. Most legislation does follow the Financial Action Task Force's guidelines, but ultimately implementation is a matter for each jurisdiction. And even if a need does arise to be regulated, the regulatory requirements across jurisdictions will not be the same. I think it's worth briefly mentioning also that if you are a business that issues tokens or is thinking about issuing tokens, then you will have to consider whether that of itself attracts regulation. Utility token issuances in some jurisdictions are regulated, but in many offshore jurisdictions, they are not. Now, in terms of AML and KYC, Saji has already alluded to the fact, as have I, that the world post-Panama Papers is a very different one. Most reputable offshore financial centers now do require their companies, agents, and other regulated entities to know who the ultimate controllers are and to conduct rigorous AML and KYC checks. Not only is this a reputational issue, but jurisdictions that do not implement a framework to facilitate this type of information and document collection and impose fines on market participants that fail to do so are highly likely to be added to the Financial Action Task Force's blacklist, which has potentially adverse consequences. Now, as a business expanding in Asia, I think you can either accept that AML and KYC is important and will need to be conducted on controllers such as directors and shareholders when using an offshore vehicle in one of the better regulated offshore jurisdictions, or you can opt for a less regulated jurisdiction that probably does come with a lesser reputation. And I don't think there is a right or wrong here. And indeed, we have assisted Asian clients that have started in a jurisdiction such as Panama, which is less regulated, and then redomiciled the business to the BVI or the Caymans as it has continued to expand. Next slide, please. Now, as a business, you, of course, do have to weigh up the cost of establishing an offshore operation against the benefits. I don't want to get into specifics. Of course, I'm happy to take questions on it. But in general, offshore companies can be incorporated for a few thousand US dollars. Any maintenance fees will also be relatively low and no more than a few thousand US dollars. Taxation, of course, is important. Many jurisdictions, including the BVI and the Caymans, are tax neutral, which means that they do not themselves impose any taxes. Though keep in mind that this does not mean that dividends or distributions in the hands of the ultimate beneficial owners, for example, are exempt from tax in accordance with the usual rules of the place where they are a resident. Most offshore jurisdictions also have no withholding taxes. Double taxation treaties are potentially also relevant. And in fact, it's a double taxation treaty between India and Mauritius that has made Mauritius SPVs attractive to Indian businesses in the past, although even this is changing following amendments to the double taxation treaty last year. I think currency risks and exchange controls are also relevant. Many major offshore financial centers use the United States dollar, such as the BVI, or use currencies that are pegged to the dollar, such as the Cayman dollar. Most offshore jurisdictions also do not impose foreign exchange controls. Importantly, offshore financial centers do offer predictability and stability. There is very much no concept of regime change or trade wars in these places in the sense those terms are commonly used. And I don't think it's hard to envisage the benefits of incorporating the jurisdiction that has stable laws, a clear and predictable legislative agenda, and a neutral attitude to doing business with other territories when planning your expansion strategy in Asia. Now, we all know that we live in an age where trade is increasingly regional, nationalist, and protectionist. Perhaps the best example is Trump's policy of America First. But offshore vehicles can very much overcome some of these ideological barriers. For instance, can you imagine US investors investing in a Hong Kong limited partnership fund, given the existing political landscape or from a policy perspective? A couple of years ago, the Hong Kong Limited Partnership Fund was thought to potentially overtake Cayman private funds in a few years ago when introduced. But unsurprisingly, this has not happened. And in fact, uptake has mostly been by Chinese managers. And I think this is where offshore financial centers that are neutral in their approach play an important intermediation role. Think also VIE structures, which I've already mentioned. These very clearly facilitate investment into China. Now, the Web3 space raises its own unique commercial considerations when making a decision on offshoring. Culturally, confidentiality is really important in Web3, and the controllers will often want their identities to be protected. offshore jurisdictions do offer different solutions to this that I will look at in the case study in just a moment. Unlike in some onshore jurisdictions, there are no overarching restrictions on the types of assets that most offshore companies may hold. I don't think you can say the same for other jurisdictions, which, as an example, outright prohibit the holdings of bitcoins or other digital assets. Now, we all know that what the market expects and what investors want is very important commercially and culturally for Asian businesses. Get tied is probably not a great idea because it may raise questions and spook investors. Sector and geography does play an important role. So I've already mentioned that Cayman companies are very popular on the main board of the Hong Kong Stock Exchange. Equally, for historical reasons, Bermuda companies are popular in the insurance and reinsurance sector. And Jersey companies play a crucial role in many commercial property matters in the UK, including where Asian investors are involved. Next slide, please. Now, I'm going to just skip this purely in the interest of time, but I've set out on the slide a couple of high-level points to consider in order to mitigate some of the types of risks that I've talked about. So let's move on to the case study. Next slide, please. I think it does make sense, before moving on to taking questions, to put some of the concepts to play by looking briefly at a case study. And as a legal practitioner, I'm going to mostly focus on the legal considerations in doing so. So what are the facts? Well, last year we were approached by a client with considerable legal and financial services experience to set up a structure and advise on a new Web3 business looking to launch in Asia. And the goal of the business was simple. It was to simplify crypto trading for users on a specific blockchain using AI technology, where users would draw upon their own digital assets in wallets on the relevant blockchain, and trades would be settled on a third-party regulated exchange. So in other words, the business was going to develop an app powered by AI technology. Trades would be executed on a third-party exchange, so not by the client business itself, and the client business would not maintain the wallets themselves, so they would not hold custody of any of the assets. And in instructing us on this, the client's key considerations were the following. There will be geographically diverse investors, so the holding company must be incorporated in a reputable and neutral territory. This was a startup business, so understandably the client did not want the business to be regulated, if possible, to avoid the cost implications and regulatory burdens that regulated status entails. The client wanted to safeguard his privacy and confidentiality as a director and shareholder. There was a need to ensure that distributions that are paid by the underlying business do not fall in the hands of the founders immediately, as this may entail adverse tax consequences. And the client wanted to clearly document the rights of the investors and founders in an agreement among themselves. And so you can see the structure that we came up with to facilitate this business on the slide. And I'm going to elaborate on a couple of key points into the thinking that went into this structure. So you can see that funds from the investors and the founders will flow into a Cayman company. We chose Cayman because Cayman as a jurisdiction is highly respected worldwide, and we knew that this would facilitate investment from geographically diverse investors in line with the client's objectives. There are also no applicable taxes in the Cayman Islands, and whilst the investors will no doubt request financial information to be prepared contractually, there is no underlying obligation under Cayman law to prepare financial statements, or indeed, if you do prepare them, to have them audited. The Cayman company will be a pure equity holding vehicle, so in other words, it will be a holding company business, which means that it can easily satisfy the reduced economic substance test that I've touched upon. This Cayman company also does not need to be regulated, and again, that meets the client's objectives to remain cost efficient. The founders opted to hold their shares in a Cayman company using a BVI company. And the purpose of this was to protect privacy and liability of the founders as they are further level away from the principal holding company, and also to facilitate the payment of a distribution by the Cayman company in a way that it does not immediately fall in the hands of the founders themselves. That's because the distribution would be paid by the Cayman company to the BVI company. And as many of you probably know, BVI companies are very cost efficient. And this is why BVI, as opposed to Cayman or any other offshore jurisdiction, was used for this purpose. Now you can see that there is a shareholders agreement between the investors, the Cayman company, and the founder, SPV. Cayman law is highly flexible as to the corporate governance of a company. So the commercial discussions dictate provisions with respect to things like preemption rights, share transfers, board and observer rights, board and shareholder reserve matters, and any other terms that are required by the investors. You can see that the Cayman company holds all the shares in the BVI subsidiary, which is responsible for developing the AI technology and the trading bots. And in deciding on the BVI as a jurisdiction, we had to keep the client's desire to be unregulated in mind and to issue a legal opinion to confirm that the proposed activities will not be regulated under BVI legislation. And we had to, in fact, obtain the BVI regulators' views to reassure the client, which we did promptly. That is not something which would have been possible in many other jurisdictions because the regulators do not engage in those types of discussions. We also established that this company would not need to satisfy the economic substance test and discussed how key intellectual property may be protected. Last of all, the client wished to protect their identity as shareholder of the founder SPV and as a director of each of the BVI companies and the Cayman companies. And this was a concern because third parties can pay the company registrar a nominal fee in the BVI and the Caymans to obtain a list of the existing names of the directors. And so what we did was that we appointed a Seychelles company as the corporate director of each of these companies, of which the client is a director in his personal capacity. There are no publicly accessible directorship searches in the Seychelles, so this resolved the client's concerns. And we could, of course, also have appointed a nominee instead, but that's more expensive than appointing a corporate director, which was not in line with the client's objectives. So thank you very much for listening. I'm now going to hand back to Miguel, who will coordinate questions.
Thank you so much, Peter and Saji, for your insightful presentations. I believe that you guys have given us a lot to think about, and I'm sure our audience has plenty of questions to deepen their understanding. Now we'd like to open the floor for the Q&A session. If you have any questions, please feel free to type them into the chat box, and we'll address as many as we can. To make the most of our time, please, I kindly ask everyone to keep their questions as concise and as relevant into today's topics. Let's get started. Our first question, we have it from Peter. Peter is asking, it's from Peter also asking, could Peter comment on the impact of ATAD2 on the use of BVI and Cayman entities? ATAD, for those who are not familiar, the Anti-Tax Avoidance Directive. So, Peter, can you please answer the question?
Thanks, Miguel. Can you just say again which directive are we talking about here?
ATAD2, Anti-Tax Avoidance Directive.
Okay. I'm not sure what jurisdiction the question is referring to.
Cayman. BVI and Cayman.
Well, I think the point is that, as has been alluded to both by myself and Saji, BVI and Caymans are tax neutral jurisdictions. By using them, it does not mean that the ultimate beneficial owners of the relevant entity do not need to pay taxes in the jurisdiction in which they're ordinarily resident in accordance with the usual rules of taxation. So an important point to understand is that the use of BVI and Cayman companies does not facilitate tax evasion or tax avoidance. What it does do is facilitate tax planning. And you can have a look at the example I gave in a case study where a dividend paid by a Cayman company to a BVI when it's tax neutral, but then as soon as the BVI company makes that dividend to the UBOs will need to pay taxes in the jurisdiction where they are tax resident. So not tax evasion, not tax avoidance, but effective tax planning. I think that's the key takeaway.
Okay, perfect. Thank you very much, Peter. We have another question, but it's on the chat, so please post it on the Q&A. I have another question from what is an unverified attendee. And I think this question is also for Peter. Peter, be ready. So the banking is still an issue in Seychelles, Mauritius. What is the situation and the legal framework when to global banking? For example, fintech providers using BIAS platforms with international custodian.
Well, look, we recognize that banking has become increasingly more difficult, especially for unregulated businesses, and particularly for businesses that do not have an established track record or previous financials. But it does remain possible to open bank accounts. If it didn't, we would not be in business. In many of the offshore jurisdictions that we advise on, it is not mandatory to have a bank account in that offshore jurisdiction. You could have a bank account anywhere. And so we often advise our clients to leverage on any existing banking relationships they have. You know, the big banks included Standard Chartered, HSBC, DBS, and we know from our own list of clients that these banks will open accounts for offshore companies if they provide the usual set of KYC documentation that is requested, and explain clearly why it's helpful to have or use an offshore company in the structure. So key takeaway, it remains possible, but it is getting increasingly difficult. Try to leverage any existing banking contacts that you may have to open bank accounts for your offshore company.
Okay.
Yeah, I'll add to that one additional practical aspect here. Basically, if we are looking for a good financial institution as a business case, you will have to have a proper business plan, your transactions, counterparty details, these kind of things. If we have clear, concise report to a bank, presentation to a bank, very, very small, but sort of points to which jurisdiction are you involved, what sort of business plan you have for a year, what sort of transaction you expect, those kind of details. If you have that clearly in a presentation, that will help to get through this difficult financial institution complexity, right?
Yeah, absolutely. I have another question for you also, Saji. The question says, what are the most popular jurisdictions for establishing a holding structure to invest in multiple Asian markets, and why are they favored?
Yeah, it's a good question. I mean, again, it depends on the user's preference. I mean, that's the starting point, basically. What are the jurisdiction in business involved? Where would you be investing? Let's say, for example, as Peter alluded to earlier, a US investor coming to a Hong Kong entity for investing, for example, probably a most common jurisdiction like BVI would be useful. if a Chinese investor going to a different market, probably they would prefer something with the Chinese M&A and Chinese language operational facilities in this jurisdiction. Or if an investor going to, let's say, for India, there will be a taxation consideration for Mauritius for that aspect. These are the kind of aspects looking into investing in various markets. Depending on your business plan and your business use and the jurisdiction where you or the business involved, got to carefully consider offshore jurisdictions. So, in a nutshell, if you there is no particular jurisdiction as such. It all depends on the use and particular market where you're trying to enter, and the jurisdiction domicile of the beneficial owners. Probably consideration to choose a proper jurisdiction.
Mhm.
And of course, we are here to help. I mean, if you need any expert assistance, Peter can give you legal advice and that sort of aspects, and we can also give you advice on structuring. Our experts in-house professionals can help you out with that. But in common, depending on your business nature, your market entry, and your jurisdiction of presence, those are the aspects you consider for a popular jurisdiction for investing.
Thank you very much again, Saji. In being mindful of time, we're going to have only one more question. Question is, in a time of rising geopolitical tensions, how can offshore entities serve as a strategic buffer for businesses operating in Asia? I'll leave it to both of you, Peter, Saji.
Peter?
Yeah, I'm happy to go first. I mean, I've already touched on the fact that these jurisdictions market themselves as neutral. They facilitate business transactions between different economies. It's inconceivable, as I've said in the presentation, that many US investors would directly invest into a Hong Kong business or a Chinese business. But we know from the matters that we advise on that in substance, these transactions do frequently happen through offshore vehicles. So I see offshore vehicles as an effective intermediation tool. They do connect very different economies with different values and different political and cultural expectations together. So that's my take on it.
Perfect. Sorry,
Yeah.
Saji.
To add to that, I mean, as Peter mentioned, offshore jurisdictions are quite neutral in that sense, and a flexible framework of regulatory aspect as well. And you can use one of this offshore jurisdiction to enter in any market in that sense. Because of these various advantages. I mean, flexibility for one, and it's neutral. There's no tax complexities. And even today's regulatory framework, offshore jurisdiction is still much more easier to operate than many onshore jurisdictions. So commonly, it's a holding company vehicle to invest in various markets, and you can still manage your regulatory aspects rather easily.
Yeah, thank you very much again, Saji, Peter. I mean, we have some more questions in the pipeline, but we can maybe more go to the last slide. Again, thank you very much again to Peter, Saji, all the attendees that we had today. Just to wrap up, I mean, I wanted to let you know that we have, you can enjoy this bonus free 15 minutes one-on-one consultation with Peter, our colleagues here in Acclaim. You can just drop us an email on the email that you can see on the screen, eili@acclaim.com. But anyway, you are going to receive a follow-up email. I believe it's going to be today, tomorrow. So you can just reach out after that, and we'll be happy to answer any question you have about the topic today. And once again, thank you very much, everyone. I really believe it's been a really engaging session today, very insightful. Thank you very much again. Thank you.
Thank you. All right.
Thank you.